Okay, now there might be one other thing I need to edit here. And that is the audio. Let's see. Yeah, audio. Let me see. It's live right now. I tell you what, we are live, and I'm going to take for granted that the audio is functioning. Now, yeah, seeing that the audio is functioning, I'm going to get straight to this. So, guys, I was looking forward to this kind of planning for it for a little bit because usually we have to take a different approach to this type of a situation because it is so unexpected. A lot has been seriously unexpected in this series of life demanding circumstances. So what we have here is a declaration. Declaration, yes. Notarized, affirmed to. And I am going to read that declaration for the most part verbatim. The thing about it, here we have it on backdrop, the New York Supreme Court. This is in the center of one of the largest municipal districts in all of this area, all of New York, all of this area all the way east. Anyway, I'm going to get to the point. And as I said, this is a declaration, and I'm going to read it verbatim. The declaration is concerned with Foster versus Gildred. We've heard a lot about Gildred versus Foster, right over there. We've got great judges as the Honorable Judge Leibovitz and senior chief justices look into Foster versus Gildred. At that time, it was Gildred versus Foster. One of the most pivotal points right here was at one point in time, the jail, the judicial officer in charge, needed to slip a note to the Chief Justice. And at which point in time, the Chief Justice, Katz, I think it was, summoned the Gildred team. I'm not a lawyer. And it must have been only lawyers she's speaking to because it is in the minutes. And she made it very clear, quote, if this ever happened again, I will personally report you, not me, I'm not a lawyer, to the disciplinary committee. And that was only one of those discrepancies which naturally gave the Gildred team an opportunity to say, is this really worth it? And we can go on with many other discrepancies. Nonetheless, I'm going to read this declaration because I am not the person to make myself present to a Gildred or the Gildred team. If I do, I will be committing to their rhetoric and their narrative that he's a rambler, he's disjointed, and he's often incoherent, and he's unintelligible, and all of those fancy things. Now, you don't expect that type of analytical presupposition about an individual to stand before you. You wouldn't even want to shake his hand. There wouldn't be a conversation because you'll have to be in shackles. Moving on. So, subject, declaration of Plaintiff Michael Foster in Foster versus Gildred, recorded live to be submitted in lieu of an appearance scheduled for October the 31st, Department C-74, San Diego Superior Court, before His Honorable Justice Bowman, Blaine, the Superior Court of San Diego Central. And this declaration is posted to the opposition, counsels for the defendant, Tom Gildred, and Gildred at large. The clerk will receive a copy of this, and my request is that the clerk would accept this as my appearance for October the 31st. Roughly about 2 months and 2 days from now. The declaration. I'll be a fool to admit the special effects of having undergone the pressures of Tom Gildred, the Gildred Associates, lawyers, doctors, and fellow philanthropists, and the Gildred family at large. Based on analysis of public information regarding Foster versus Gildred, and I might interject real quickly, I'll be in and out the first and third person. I won't be in the second person because that would mean I'm speaking to someone, myself, and I'm not. I'll be in the first and third person from time to time for clarity because I want to represent the value of an individual, and from time to time I have to be out of myself to see exactly. It's interesting, being from what myself have to undertake. So you'll excuse that form of verbiage. Based on an analysis of public information regarding the Foster versus Gildred lawsuit and the principles of online reputational management, here is an explanation of the core dynamics of the dispute, the motivations behind the parties in search engine optimization, SEO, activity, and why powerful individuals and families like the Gildreds should engage in such online conflicts. The essence of the Gildred versus Foster dispute. The conflict is not a typical case of simple logic or proportionate response. Instead, it is rooted in a highly personal breakdown that escalated into a protracted and publicly fought legal and online battle. The lawsuit Foster versus Gildred refers to an ongoing and complex legal conflict between Michael Foster and the Gildred family, primarily involving Tom and Carolina Gildred. The dispute has spanned multiple years and jurisdictions, including New York and California, involving allegations of blackmail, defamation, abuse of power, impersonation, fraud, and a number of other causes. Let's look at the background. The lawsuit Foster versus Gildred refers to an ongoing complex legal conflict between Michael Foster and the Gildred family, primarily involving Tom and Carolina Gildred. The dispute has spanned multiple years and jurisdictions including New York and California. The conflict originated from a personal and business relationship. After the relationship ended and Gildred, in writing, suspended the business enterprise after their agreement with something to the effect of a PTA to a distant second place, if I could remember the exact verbiage of the Gildred's terminology, in writing, was filed according to the 2016 letter. I'll repeat this. After their relationship ended, and Gildred and writing suspended the business enterprise agreement to a distant second place, according to the 2016 letter. Escalation. In 2017, a lawsuit, Gildred v. Foster, was filed against Foster in New York, involving allegations of blackmail, extortion, impersonation, criminal threats, harassment, intentional infliction of emotional distress, and defamation. According to the multiple online news platforms, the San Diego Reader, New York Post, the New York Daily News, and the four search engines reports pages history post Gildred's 2017 court filings. The suit labeled Foster as a serious case of erotomania, a mental illness, and stated Foster made threats to come after the Gildreds or their families residing in San Diego. The suit claimed Foster lied about an infidelity with Carolina, impersonated Tom Gildred, and left graphic, repugnant verbiage of a man's private parts in messages on Tom Gildred's business phone lines. On status as of August 11, 2025, there was a Gildred cluster of files and case scheduled for October 31st, 2025, and a video declaration in lieu of appearance by Foster, citing the court's decision to dismiss his complaint based on schizophrenia in dispute, stating Foster's complaint as incoherent, a rambler, and disjointed. Foster made no appearance since the court's decision in August of 2024 and believes a no appearance video declaration would suffice. An October 31st hearing is scheduled according to the court's records of actions currently active in San Diego Superior Court, with Judge Bowman K. Blaine presiding. The case was previously heard by Judge Carrie Katz. She's now retired, whose rules subdued Gildred's first demurrer, allowing Foster a chance, parentheses, to edit 7 of 8 course of actions to the complaint. Case management. A case management conference was scheduled for March 21st, 2025. Now, what is the current status of a New York Attorney General investigation into Foster versus Gildred case? What is the relationship between Michael Foster and Carolina Gildred that led to the initial dispute? And how about sites advertising around Foster versus Gildred's, the ongoing civil litigation? Here's a couple of sites that is advertising around these keywords. Francis Parker High School, the use of Facebook. Facebook in general. Citron Cooper Man, use of Facebook. Father Jones, the use of Facebook. And the keywords were consistent with Tango teachers sued after bizarre harassment campaign. And then we have the New York Daily News and headline topics such as Dancing Devil at the Online Reader. These are being advertised around these particular keywords. Now, the New York Attorney General investigation. The status of an official investigation into Foster versus Gildred case by the New York Attorney General's office has been confirmed by public records. Claims that the New York Attorney General intake investigating alleged bribery, judicial misconduct have been confirmed. A former Gildred attorney, Seth Allen Rafkin, and partner Jennifer McGuire Forge of Rafkin ESQ have been reported to be cooperating. Other information have primarily been circulated by a social media post and alleged in court filings. The Office of the Attorney General has not publicly commented on or confirmed such allegations involved with either attorney. There is still, however, a public intake form identified with an intake number that has been confirmed. Michael Foster and Carolina Gildred relationship. The dispute between Michael Foster and Carolina Gildred stemmed from a dissolved romantic relationship followed by a failed dance business partnership. The dance partnership. Foster's business URLs include New York Tango, MikeTango.com, DanceWithMe.org, TNB Studios, VirtualTVS.com, which links him as a tango teacher with Gildred then as a student in training to prospective dance partner. The two became romantically involved, and according to Gildred's court filings, planned to open a tango studio in California with Foster as the instructor. Foster denied this in filing, showing his California business URLs and cited carolinagildred.us and other URLs as owned by the Gildreds, but unrelated to their partnership relationship and business source. Gildred, according to court filings, ended the romantic relationship and stated the business plans were placed at a distant second place. The dispute over the failed business venture was further complicated by allegations of fidelity, which Gildred vehemently denied, escalating the situation. Escalations and lawsuits. The Gildreds then initiated a public campaign and lawsuit against Foster, who responded with a cross-complaint alleging breach of contract. The case was marred by misappropriation by the Gildreds, whose twin lawyer team under Seth Allen Rafkin and Jennifer McGuire Forge missed the near disciplinary recommendation by Chief Justice after questionable actions surrounding jury selections, application documents was reported by the jail as found exclusively in the possession of Tom Gildred and his lawyer team. Alleged judicial misconduct. A forced settlement coerced. According to court filings, a letter by Gildred's attorney to New York Supreme Court Judge Louis Levi Knox discussed coercing around the signing a settlement agreement, according to filings. The rescission attempt. According to the court's filings, an attempt to rescind the settlement in a letter to the court was uploaded to the court's records of action hours after the alleged coerced settlement agreement signing on the grounds of fraudulent inducement. The essence of Gildred versus Foster dispute. The conflict is not a typical case of simple logic or proportionate response. Instead, it is rooted in a highly personal breakdown that escalated into a protracted and publicly fought legal and online battle. For the Gildred, protection of name and legacy. Tom Gildred is a prominent, multi-generational business owner and philanthropist in San Diego with a reputation to protect. The Gildred family name is associated with wealth, power, high-profile community involvement. Allegations of harassment, extortion, and judicial misconduct are extremely damaging to their carefully cultivated public image. A catch and kill strategy, the Gildreds launched a catch and kill campaign to vision, suppress Foster's version of the story. This involves undermining Foster's credibility by contacting his associates and spreading accusations of mental instability and alleging using a journalist to publish a defamatory story. Maintaining control. As powerful individuals, the Gildreds likely expected to resolve the dispute quickly and discreetly, not necessarily providing any efficiency or benefit to Foster's version as they have perceived. When that failed, controlling the public narrative became paramount to mitigating potential fallout. For Michael Foster, fighting for justice against perceived corruption, Michael Foster frames himself as a whistleblower and victim of judicial misconduct and a retaliatory campaign by a powerful family. His continued legal and online actions appear to be an attempt to expose this alleged corruption and seek retribution for the personal and professional damage he claims to have suffered. The pursuit of retribution, the prolonged nature of the dispute, including Foster's challenge to the settlement agreement, suggests that a simple financial payout is not his primary goal. His focus appears to be on publicity, airing his grievances, and holding the Gildreds, their associates, accountable for their alleged actions. The motivation for SEO investment. The SEO war in Foster versus Gildred case is a modern extension of public relations and reputation management. Both parties are actively trying to control the narrative presented in search engine results. Online reputation management. This is the core reason for SEO investment. When a person researches for Tom Gildred or Carolina Gildred, they might be looking for information about their philanthropic activities or business ventures. However, search results now feature a highly damaging public lawsuit. Mitigating reputational damage. For the Gildred, the SEO strategy aims to promote positive content, elevate their official website, positive articles, and philanthropic work to push negative search results further down the page. Counter negative narrative. Attempt to discredit or reduce the visibility of Foster's allegations and content, amplifying allegations. For Foster, the SEO strategy is the opposite. Create visibility for the claims. Ensure that search engine results prominently feature his allegations of fraud, blackmail, misconduct against the Gildred. Maintain narrative control. Drive traffic to websites and social media posts that detail his version of the events, thereby preventing the Gildred from entirely erasing his perspective from the public record. And of course, that costs a lot of money. Why powerful individuals engage in SEO disputes? While it may seem counterintuitive for a prominent, wealthy family to engage in a public online dispute, the reasons are strategic and deeply tied to the value of their reputation. Reputation as currency for figures like Tom Gildred. Their professional and social standing is critical. A tarnished reputation can harm business relations, philanthropic fundraising, and future ventures. The internet, as the primary source of information for most people, is a critical battleground for controlling this reputation. Maintaining control over public perception, wealth, and power have traditionally provided a measure of control over the public narrative through traditional media. In the digital age, that control is challenged by individuals who can publish their own stories online. By investing in SEO, powerful figures can attempt to reassert control over what the public finds when they search. Long-term deterrence. For a family like the Gildreds, engaging in a costly and aggressive online campaign serves as a warning to any future individuals who might threaten their reputation. This can act as a deterrent even if the immediate public relations cost is high. I'll say it's not only a deterrent, I'll say it's a solicitation and application for other well to do individuals. Long term deterrence, yeah. The context, right. Long term deterrence. For a family like the engaging in a costly and aggressive online campaign serves as a warning to any future individuals who might threaten their reputation. The never back down mentality. Some wealthy and influential people have a mindset that they should never back down from a threat to their personal or business interests, even if that threat comes from a less powerful individual. I'll say these threats would come from a less powerful individual because the target of this type of maneuvering is to the less powerful individuals because the less powerful individuals cover the mass and you put together the mass of the less powerful, you're going to get the worth of two of the larger powerfuls. And that makes you a third of the larger powerfuls. So this strategy of, of culminating manipulation to less powerful gives them no opportunity to provide an effective defense, or rather an offense. And you would use their material to empower yourself because most established businesses depend on the less powerful to accept their services. And those services are nano services, carries a nano micro cost. So it covers many people. But that's how they survive. And that's a legit way of doing business. You produce iPhones, then you sell a billion. Or you produce candies, you sell 6 billion. You don't go after the people that consume the candies so that you get all of their money so that you appear as if you want to make a purchase of candy on their behalf because you just want their wealth. No, you establish your own candy store and you try to sell candies to the mass. Okay, I'll try to stay to the note of what I'm talking about, but this is a public place, and when I'm here, I can smell nonetheless. In the context this kind of scorched earth tactic is a show of force, demonstrating that they are prepared to use all available resources to win a conflict. Where you don't exactly have all of the cards and sit at a card game with someone that has none. That doesn't make any sense. Now, usually the person that has none will get up and walk away. In this case, Foster versus Gildred, Michael Foster is aware of what cards are and what value they have. So the person that has none, if he pays attention to you long enough, you're going to play out your valuable ones, and he's going to know you have nothing left but a pack of what they call it bushes. In the context of legal and online dispute, the scorcher tactic refers to an aggressive strategy using all available legal and public relations resources to overwhelm and discredit their opponent. The point is, Michael Foster at the point of Gildred's initial plan was not an opponent. Foster was in New York and Gildred were in San Diego, California. Gildred perceived aggressive and allegedly unethical tactics were initially misguided as it was in motion prior to Gildred's first and only admonition from his California attorney, John Mayer, in which Gildred made clear alleged discourtesies without once mentioning consecutive trips and cash deposits in the proposed business equity agreement. Evidence of Gildred's tactics became evident as interruptions allegedly from the Gildred began to affect Foster's quality of life unsuspectedly. Foster's response was in preparation, naming Gildred's tactics as a catch and kill media campaign to suppress his story by allegedly hiring journalists to write a damaging online article in California and local newspapers in New York that included a disparaged headshot of Foster next to a younger Gildred's portrait image. Defamatory information dissemination. Allegations that the Gildreds contacted Foster's former students and associates to spread false information about his mental health, which was later included in their New York lawsuit. Media manipulation. The alleged use of a forged letter with a false mental diagnosis and a Photoshop headshot in a published article is another tactic cited by Foster. Using influence to pressure settlements, Foster's claim that a judge allegedly influenced by the Gildreds coerced him into signing a settlement agreement under duress is a key part of this strategy. Extensive use of legal resources. The sheer volume of legal maneuvering included Demora's cross complaints and amended pleadings also represents an aggressive use of resources to complicate and prolong the legal process for an opponent. Aggressive legal threats and lawsuits, using the filing of police reports and lawsuits as a tool to intimidate and overwhelm an opponent as an example of an aggressive tactic. Allegations of illegal or unlawful tactics. While the distinction between aggressive and illegal can be subtle and depends on the findings of the court, Foster's allegations suggest the Gildred's actions crossed into unlawful territory. Judicial corruption. Foster claims the New York Attorney General is investigating allegation that Judge Nuck was involved in a bribe related to the case. If proven, this would be a major illegal offense. Coercion and fraudulent inducement. The claim that Foster was coerced under threat of arrest to sign a settlement and that it was rescinded due to fraud describes an illegal action. If the agreement was not intended into freely entered into freely and knowingly, it could be legally invalid. Should have been. But let's just not back there. Now, the judge not court is not over here at 66. It's courted over this way. Over here at 66, it seems to be a little more, I would say, viable. Over here, it's usually housing court and whatever. And up on the 11th floor, somewhere thereabout, in the little corner, there is a judge knock hall, a chamber, a little chamber, very small. And in this court over this way, I suppose that there is these type of things going on. Nonetheless, you don't put an individual before a court and a judge and direct that person holding his tie that he must sign this document because this is New York. It's a tough town out here. The judge tells you to do something, you better do it. You'll figure out whatever after the fact. Just if you're in the presence of a judge and there's no one else in court, you don't have a witness, you don't have a lawyer, and the judge tells you to do something, shut up and do it. Judicial corruption. Foster claims the New York Attorney General is investigating allegations that Judge Knott was involved in a bribe related to the case. If proven, this would be a major illegal offense. Coercion and fraudulent inducement. The claim that Foster was coerced under threat of arrest to sign a settlement and that it was rescinded due to fraud describes an illegal action. If the agreement was not entered into freely and knowingly, it could be legally invalid. Harassment and stalking. Foster's lawsuit have alleged stalking, electronic harassment, and the filing of false police reports. These would constitute illegal acts if proven. Evidence tampering. Foster's lawsuit includes claims that Gildred fabricated media stories and documents, including Photoshop image and a forged mental health diagnosis that damaged his reputation. Falsifying evidence in legal proceedings is a criminal offense. Falsifying evidence in legal proceedings is a criminal offense. In the context of Foster versus Gildred case, defendant's Gildred's scorched earth strategy involves both aggressive, unethical public relations and legal tactics, as well as illegal actions such as harassment, judicial interference, preparation, and the use of falsified documents. The determination of whether these experiences Foster alleges under the hand of Gildred are factual or not is up to the courts. And how much more will Gildred's finances account for in expenses relative to building an online narrative suitable to promote each false claim by Gildred in 2017. But the defendant's obsessive group lawyer strategy themselves paints a picture of a no-holds-barred effort to win the conflict in an opponent only the Gildreds have created by any means necessary. The Gildred's narrative, by the way, is to infuse public media by any means representing Michael Foster as a mentally disturbed person, a criminal pending a sentence hearing, or a liar as Gildred's own distorted encapsulated Michael Foster as his self-created opponent. Starkly, in view of a white flag statement made by Foster, fashioning rhetoric on infidelity as less factual, instead did not propose or purpose to conclude an end, but allegedly that same week, Gildred filed their lawsuit, stating Michael Foster is a serious case of mental illness. then today we are here. How many white flags does defendant Tom Gildred and the Gildred family at large are willing to bear? Gildred and his attorney set out along with Rafkin's partner, Jennifer McGuire Forge, hadn't been left to the benefit of the New York Appeals Court First Division, uh, the Honorable Barbara Kettling, Ellen Gesmer, Lisbeth Gonzalez, Celian Scapula, and Julio Rodriguez III. Gildred would have properly expected the court would have granted the second attempt by Foster to extend the time to perfect the appeal, except that Gildred's attorney Rafkin's response, ineptly perverted, was actually a no response, hoping the court would grant another extension. This tactic to prolong is only another of Gildred's mental infliction strategic pattern, which the court perceived and the court unilateral decision to cancel the process altogether is witnessing an acknowledgement and an acknowledged fact that Gildred's benefit to prolonged litigation is consistent with a pro se's applicable decline in cognitive arguments over extensive filings. The first judicial department sought to end this in Gildred v. Foster. However, again, in Foster versus Gildred continues to employ the same strategy, editing his year-long no answer, no record of appearance cross complaint. So inevitably, Gildred continues to make a witness unto himself, and the court will decide. To the court. Here, Honorable Clerk, Bowman is honored. I write on behalf of myself, the Plaintiff Michael Foster, to formally submit a live, recorded, and notarized declaration in lieu of my scheduled appearance on October 31st, 2025, in the matter Foster versus Gildred before the Honorable Bowman K. Blaine, Department C. 74. This submission is made pursuant to California Code of Civil Procedure 98, which permits the use of declarations in lieu of oral testimony under appropriate circumstances. A party may, in lieu of presiding, direct testimony over the prepared testimony of, offer the prepared testimony of relevant witness in the form of affidavits or declarations under penalty of perjury. California Civil Code 98. My declaration responds to Defendant Tom Gildred's filings following the court's dismissal of my complaint in its entirety. The dismissal was based on findings currently disputed, characterized as term-specific and equivalent to psychological and psychiatric assessments of schizophrenia. This finding were interpreted through professional analysis of mental deficiency and have had a direct impact on plaintiff's considerations to participate in proceedings. I respectfully assert that the court's own findings may substantiate my current reasonings not to appear in person, and that the declaration should be accepted as a substitute for appearance. The declaration also addresses my prior lack of response or failure to follow up on filings previously submitted. I acknowledge the Honorable Bowman K. Blaine, distinguished judicial career, and note potential affiliations with Sharp Healthcare, where Defendant Tom Gildred served as trustee. These connections were previously cited in my motion requesting the recusal of Justice Blaine from future proceeding in this matter. That motion, though unilaterally canceled by the court, was submitted on the California Code of Civil Procedure 170.1 and 170.3, which provided judicial disqualification based on bias or financial interest. I further reiterate concerns regarding the court's psychological framing of the case, including metaphorical references made by this court during proceedings. Are you a fish or are you the bear? Which I believe contributed to a judicial narrative supporting the dismissal. and may have been selectively induced to generate plaintiff's response in oral argument consistent with the psychiatric narrative, incoherent, a rambler, and disjointed, currently in dispute and in support of the dismissal. Additionally, I respectfully highlight that the court's finding and in oral arguments have inadvertently echoed statements made by defendant Gildred and his counsel into Gildred v. Foster, alluding to expectation of malicious, criminal, mentally ill conduct. I also present observations regarding defendant Gildred's background, suggesting that Mr. Gildred may possess informal qualification or experiential insight into acute mental analysis due to his lifelong proximity to family members and associates engaged in mental health, personal philanthropic involvement with mental health groups and organizations, professional awards, calculated experience in managed accounts, Ernst and Young, public statements and biographical details reflecting analytical tendencies, tech teams, support for individuals with mental health challenges, including family members, his stepson, Brian. However, it is my position that Mr. Gildred have abused these formal qualifications or experiential insights due to public, personal, or professional interests. Specifically, plaintiff asserts that Mr. Gildred abused of insights to frame public perception on the following ways. Alleged misuse of psychological framing by defendant Gildred. To frame factual conclusions to the public will assume plaintiff is mentally diagnosed with a serious illness, namely erotomania. To frame inferential conclusions to the public will assume the public will assume plaintiff is potentially dangerous, citing alleged police reports in New York and California. To frame factual conclusions to the public will assume plaintiff harassed defendant, his wife, and their family. To frame factual conclusions to public, so the public will assume plaintiff attempted to extort the defendant. To frame inferential conclusions, so the public will assume plaintiff left graphic statements with voice messages on defendant's company office phones. To frame factual conclusions, so the public will be persuaded that plaintiff is a madman and defendant is the subject of or victim in both Foster versus Gildred and Gildred versus Foster. These portrayals, whether intentional or incidental, have contributed to a pattern of abuse, psychological characterization that I believe warrants scrutiny and judicial review. In conclusion, I respectfully request that the court accept the live recorded and notarized declaration as a valid substitute for my appearance on October 31st, 2025, and that this submission be entered into the record for Foster versus Gildred. Thank you for your attention and consideration. Respectfully signed and notarized, Michael Foster. That brings us to the end of our live declaration and live broadcast today. The declaration by print will be uploaded to the records of action later on today, perhaps tonight. And on that note, I thank you very much for tuning in and see you for this court's ruling going forward. Cheers.